helmets.
Where would you like me to
Sit
sit?
here next to Armen. I'll sit here.
I'll have my
Right next to
bodyguards with me.
That's right. Shall we?
Yes.
Yes. Good evening, everybody. My name is Armen Tashjian. I'm a civil litigator with substantial experience in immigration matters. So, due to the unprecedented events, primarily the ICE raids here in Los Angeles, as well as other cities, there are a lot of people that would love to get some guidance in terms of what to do. To further that, with Armenian Bar Association, we decided to be a little proactive and do semi-town hall type meetings and pro bono type services to help people out. I co-chair the pro bono committee with my good friend Mesro Kudagulian, who's sitting in the audience here. And we asked our Councilman Adrin Nazarian if he would be willing to support our effort. And without even a blink of an eye, he absolutely agreed to do that. Now, Mr. Nazarian has been in public service for over 25 years, if I understand that correctly. And he's got a wealth of knowledge and a heart of gold. So I'm going to turn over to Mr. Nazarian to say a few words, and then after that I'll turn to our panelists. Mr. Nazarian.
Thank you so much, Armen. Thank you all for being here. Thanks to the audience that hopefully is going to benefit from this program as well. As Armen said, when the Bar Association reached out, it didn't take a minute for me to say yes. I very much value the opportunity to partner up with making sure that our businesses, our local residents have the benefit of knowledge, are empowered by it, and know what steps to take to protect themselves, their loved ones, and their property. Never did I thought, especially for many of us who have fled or have come from generations of having to flee, starting with the genocide and then every upheaval in every country that many Armenians, especially Armenian Americans, have settled in until they arrived to the United States. Never did any one of us think that the United States would be going through this set of circumstances that it is right now. So in many ways, there's a feeling of being upended, and it's critical to understand and know how the laws that we cherish can now turn and protect us. So at the city level, we've taken multiple steps. Unfortunately, we're not the federal government, so we don't have the jurisdictional capability to do what we can to protect our residents from harm directly. But what we have done is taken steps by contracting out services to multiple different law firms and pro bono organizations to make sure that they're on the city's contract in order to provide the support services necessary. Two, we've partnered up with multiple food distribution organizations to make sure that we're able to work and provide necessary nutritional support to families who may not want to leave their residence or are having a tough time given the economic stress that they're dealing with to be able to buy food. So on multiple fronts, we're trying to offer support as much as possible. So my office is ready to help with anyone's needs. Don't hesitate to contact my office at 818-755-7676 or our handle at CB2 Los Angeles. But moreover, I always prefer having partnerships with individuals who know the law, have used this application to provide and extend the protection necessary, and look forward to partnering with all of you in ways that we can collaborate and make sure that our residents gain the benefit of your knowledge and the protection you can offer. So thank you all for being here. I'll join the audience. Thank you very much.
Thank you, Councilman. Seated on my right is Luiza Manuelian, who specializes in employment law and her focus today will be to educate us in terms of preparedness from the perspective of employment. What employers should know, what employees can expect in case they are targeted by any of the ICE raids. But before she starts, I'll ask Luiza to tell us a little bit more about her office, her job, where it is, and what's the name and what she's doing primarily.
Thank you for the introductions. Hi everyone, Luiza Manuelian. I work at Landiger Verano. I am an exclusively employment defense attorney, so I represent employers in both litigation as well as counseling. So I provide information on how to comply with California federal and local laws, as well as defend them in class action and PAGA lawsuits, as well as harassment, discrimination, and wrongful termination. My office is in Encino, but I have clients everywhere in California, from San Francisco to Los Angeles. And I'm happy to be here and to answer any questions. I do have a very thorough presentation for business owners, but always available for any follow-up questions.
Thank you, Luiza. Thank you. Seated to Luiza's right is Mr. Gerard Kassabian. He's an attorney with vast experience in estate planning and family planning type law. He will introduce more details in terms of his area of practice, but he's here to assist us understand and perhaps guide us in terms of what type of preparedness one should have in case the unforeseen happens. Go ahead, Gerard. Thank you.
Good evening, everyone. Thanks for being here. I'm Gerard Kassabian. I have my own law firm here in Sherman Oaks, California. I've been in practice on my own since 2010. Before that, I was in a law firm in downtown LA specializing in estate planning and family planning. And today I'll be presenting specifically about a family's needs with regard to making sure their child is taken care of in case of any kind of detention or deportation issues. So thank you so much. And by the way, I went to elementary school with Councilmember Adrin Nazarian, and I'm very happy to be here with him presenting today. We're both locals here from the Valley.
Thank you, Gerard. Thank you for that fun fact. All right, so let me start with the following question. Luiza, can you tell a little bit about, let's say, what should an employer and employee do, or how should they react in case, let's say, ICE agents barge into their offices without any warrants or anything like that? We've seen some video footage where car washes are getting busted, and some other shops and businesses. So if you can just, if you want to start with your presentation,
I mean, I can
welcome.
answer, but essentially, yeah,
Please.
that's the crux of the presentation. So let me do that and take it from there. Okay, let's make sure it works. Okay, good enough. Everyone can see? We need to go to slide. Oh yeah, that's this. There we go. There we go. Thank you. Okay, so essentially we're going to jump right into ICE raids, but to have an understanding, there are various different types of warrants and different notices that employers generally get when we're dealing with ICE. So it's really important to understand what we're precisely dealing with, right? Just a little note that this is not a legal advice. This is just presentation for educational purposes only. Sorry, gotta have the lawyer thing out. So what is your legal authority to deny ICE access without a warrant? Employers can deny access to non-public areas without a judicial warrant. Okay, and I'm going to explain to you the difference of types of warrants, but you have to designate within your location what is considered public area versus private area. So think of a general office. When you walk in, you have the general reception area. That would be considered your public area. Anything outside of that, I have recommended my clients to provide private signs on it because it depends on the type of warrant that ICE agent walks into. Employers are not required to consent to searches or seizures without proper legal documentation. This is what we've seen with clients. We get phone calls about this all the time. ICE agent comes, no documentation, shows a badge. What do people do? Panic, right? They think they have to consent. It's the same thing with police officers, right? When they come in, do they have a warrant? Do they have any documentation to search or seize? So the key here is to understand what they have and what proper documentation they have. AB 450 prohibits, okay, voluntary consent to ICE access to non-public areas of records without a warrant or subpoena. This is really important to understand, right? You as an employer cannot allow them to access private areas if it is an administrative subpoena. Okay, so we're talking about judicial warrants, which is very different than administrative warrants, okay? Judicial warrants is a warrant that a judge signs. An administrative warrant is one that an ICE agent signs. So judicial is a lot more strict, and it actually requires a judge to review with specific requirements. Only judicial warrants grant access to non-public areas. So the moment ICE agents walk in, you have to ask, where's your documentation, right? You need to ask that question. If ICE presents a judicial warrant signed by a judge, employers must comply with its terms immediately, but only for the scope authorized in the warrant. As some of you who practice criminal law in this very small room would know that any kind of warrant, right, has very specific limitations of what they can and cannot do, whether it's warrant for an arrest, warrant for documents, warrant for product, it needs to specify. For example, if it permits seizure of I-9s, which is the application form employers must have, or interviews of specific people, right? Only those people and those items are allowed, nothing more. Subpoenas. So besides warrants, right, ICE agents can also have subpoenas. Administrative subpoenas may require document production, but not physical access, right? This is the distinction between judicial versus administrative. ICE can issue an administrative subpoena for documents under 8 U.S.C. 1225. Even then, the employer has a reasonable time, usually 3 days, to comply. So what do? You get a subpoena, you call your lawyer. You do not produce anything, because even with I-9s, and I'll go over a little bit more details, it needs to be redacted. Because you as an employer are gonna walk a very fine line when you're producing too much private information of your employees, as opposed to not complying with a federal warrant. So you have to be careful what you produce. Immediate production is not required unless specifically stated and justified under law. I-9 documents. ICE must issue a notice of inspection, what we call NOI. Usually the employer has 3 business days to respond. AB 450, and this is an important one if you're a business owner, and I know we have some business owners in the audience. So if you get an I-9 a notice of inspection form, right? You can't just voluntarily provide your employees' personnel files. In fact, you can get into trouble for providing that information. You have to verify and copy all legal instrument before responding. Only I-9 forms and associate documentation should be produced. Redact unnecessary personnel information. And this is important part because if you produce your employee's personnel file, which could trigger HIPAA violation, right? Because personnel files could have everything from workers' compensation records, medical restrictions. Now you, as an employer, are going to be in trouble for not complying with HIPAA laws. So it needs to be redacted. I personally recommend my clients to create a separate folder for just I-9 forms, redact what's not necessary, and keep it separate from the personnel file. So if you ever have a subpoena, you are already prepared. Do not submit personnel files or wage records unless subpoenaed. And if you don't know, you know what I'm going to say, call your lawyer. employers are not required to produce documents immediately. In fact, under AB 450, as mentioned earlier, they may not voluntarily allow ICE access to employee records without a judicial warrant or a valid subpoena. Again, you have to show these documents to your lawyer before you produce anything. When does ICE get immediate access, right? When you get a notice of inspection for an I-9 audit, you must produce the I-9s within 3 business days. If you get a subpoena, you may need to produce limited records within a reasonable time. If you get a judicial warrant, that's the one that the judge actually signs, you have to comply within the scope of the warrant. If it's an administrative warrant, you have no obligation to comply. You can deny access that is not public, right? And no documents presented. So this happens a lot. Actually, we get calls about, hey, ICE agent just showed up. What are we supposed to do? You don't do anything. They have to show you documentation. If you have no documentation, you have to say you cannot. We do not consent to you going into our private area. And you have to document everything. What are your responsibilities as an employer to your employees, right? Under AB 450, employers must notify affected employees within 72 hours of receiving a notice of inspection. Provide the notice, the scope, and any relevant employee-specific requests. So if you get the notice of inspection from ICE agent, you have to tell those employees who are there, who they're investigating, that, by the way, ICE is looking for you, right? They're asking for this information. You also have to provide the affected employees with a copy of the notice of inspection and contact for legal assistance. Document all ICE interactions for legal review and defense. Employee rights and source authority. Employee rights are grounded in the Fifth Amendment, right against self-incrimination, and California Labor Code 1019.1, which protects employees from retaliation based on immigration status. So for those of us who practice employment law, retaliation is a common cause of action that we defend all the time. So this is specifically, as an employer, you cannot retaliate against your employees based on their immigration status. They have a right to remain silent and not produce documents voluntarily, right to legal representation before answering questions, and a right not to be retaliated. Employees should be trained not to engage with ICE agents, not to show documents, and to calmly request legal representation. Rights education cards can be distributed. So what does this ultimately mean? You need to educate your employees. You need to give them like a little cheat sheet. Hey, what happens when ICE comes? You need to do X, Y, and Z. You need to stay calm, do not consent to anything, do not volunteer any information. You don't have to talk to them unless they specifically have a warrant for you. Right? And that's really important. So training your employees of what they cannot do and what they should do is really critical, because they all get shocked at the time when it occurs. Provide know your rights cards or scripts, right? You can literally write up a script and tell when ICE comes, this is what you say. Have your human resources or legal liaison intervene immediately upon ICE's arrival. Internal ICE visit protocol. Set up a checklist for reception and security. Designate trained responders and prepare written policy on ICE protocols. This is what we've been doing for the past few months, is creating protocols for employees what to do. Document all interactions and notify your legal counsel. So if you have an HR person, you tell them, hey, the HR person is the only one allowed to talk to ICE agents, period, nobody else. So if someone comes to the receptionist says calmly, please sir or madam, if you could just wait, I need to contact my HR person. Let the HR person do the communication, limited communication, look at the documentation and take it from there. And again, it's important to identify where is public area versus private area. So they don't just go in willy-nilly and start talking to employees, because employees get intimidated and they start talking, volunteering information, right? Consent is very important. Make sure you do not give consent. It's the same when the police pull you over and say, hey, can I check your trunk? The answer is always no. you don't have the right to that. You can, but that's a choice you make. So the key here, do you have that consent? Sorry, I have criminal defense attorney looking right at me. I had to say that one. Training should cover who speaks to ICE, how to verify warrants, steps to protect employee information, and internal reporting protocols. You need to do an annual training on ICE visits and I-9 audit protocols. First and foremost, please check your I-9 forms. There's a new one that came out this year. About every 5 to 7 years, there's a new one. It's a federal form. You must have it filled out, and it needs to be updated. The front desk staff has to be trained to request credentials and delay agent entry. That's right, you guys heard me correct. Your job is to delay it, right? Because if you're not sure what you're supposed to do, delay, tell them to wait, that they need to see the documentation, call your HR or your counsel. Managers trained on employee rights and internal notification procedures. Employers are encouraged to conduct periodic internal audits on ICE and Department of Justice guidance. Self-audits help ensure compliance and identify risks before ICE inspection. Section 1 of the form, of the I-9 form, must be completed by the employee no later than the first day of work. So the moment they come in, they apply, they need to fill out the first section. The second part, section 2, has to be completed within 3 business days of the start date. And you have to correct errors using proper audit trail procedures. So one of the things that I recommend is sending out emails or notifications to your employees. Please update any of your information on your I-9 so that you as an employer have done your due diligence to communicate that. So I've got a couple of scenarios. I don't know if you want me to go through the scenarios or if we're running out of time, I can skip this part to later.
I think we're okay, but let me just pass it to Gerard for a quick second.
Yeah.
Gerard, let me give you maybe a hypothetical scenario which could be stressful for anyone, let's say, that finds themselves in the receiving end of it. Let's assume a person who may or may not be documented, could even be a US citizen, that gets taken by ICE agents by mistake, by error. It has happened. We've seen news accounts of that as well. And sometimes those detentions may last for more than a day. In a situation of a person who may not be a US citizen, the detention may be longer than that. What tips or suggestions do you have for our neighbors out there on how to protect and plan for something unforeseen like that?
Right. The main thing that this is more focused towards parents. The main thing they're worried about is the children. That's the #1 concern. They're not worried about their bank account, their house, and whatever. They're worried about the child. And so there's 2 things that are part of this child care plan, so to speak, that everybody has thought about, and there are certain other things that they didn't know that are available to them. Of course, one of them is the traditional way of, hey, in case something happens to me, would you take care of my child, your friend, your best friend, your cousin, your brother, your sister, mother, whoever, relative or friend. There's pros and cons to these, where it's easy to do to a trusted person, but at the same time, that trusted person has 0 legal rights. If they walk up to a school, they're not on their list of trusted people in a case of emergency. Of course, we know that when we register our kids, there is a list of emergency contacts, but they're only allowed to either pick up or drop off, but it's not much more than that. So it's a good thing to have that trusted person. But that leads into the second thing, where that trusted person, when they take the child into their own home, which is, keep that in mind, they may sign what's called a caregiver's authorization affidavit. This is a form, this is a California specific form, where it allows the caregiver, it's filled out by the caregiver, not by the parent who's detained. The caregiver who has the child in their custody, in their home, must be in their home. They complete this authorization. It gives them a level of authority when they go to the schools. First, it proves the child's residence, that they are living in this district and that they're able to attend this public school or wherever it is. Second, it gives that caregiver the authority to discuss medical and school-related and medical-related items that are related to the school. Okay, it's limited. It does not affect the legal rights of the parent. This is just like a care custodian arrangement. There's no transfer of rights. And if the child stops living with this individual, that document is no longer, no longer valid. There's a third thing that they can do, but it doesn't really apply during these emergency situations when somebody is detained, is a guardianship, which requires a court petition and court approval, and even on an emergency basis, again, it's going to take time, but there are things also you can do to prepare for that if somebody was to do a guardianship a petition. When they do a guardianship petition, they need to tell the judge that they're the best person to act on behalf of the child's best interest. So when they do that, the judge has to figure out who, let's say 2 people petition and they have to figure out who's going to be the one. Are they going to appoint both of them, or is it going to be the best friend, or is it the grandparent, whatever? They do have a certain form that the state of California has prepared as part of the forms that we use when we present documents to the courts. It's called Form GC-211, Nomination of Guardian. I can nominate a guardian for my child if I was to be in a situation where a guardianship was filed. For example, I've been detained, but I had prepared a nomination saying, if I'm detained, I want this guy to act. There may be other people who have a priority to act before this guy, but I'm the parent and I'm saying I want this guy to act, and the judge is going to give a lot of weight to that. These are powerful things that can be done. So, and again, this nomination of guardian can be tailored to where, in case I am detained or deported, only then do I appoint this person, for example. You can narrow it down. I can go on and on about this, but just as a quick recap, the verbal agreement with a family friend or a relative, fine, we all understand that, but it has no teeth, and nobody will act on that. What gives authority to the people who need to act on behalf of the child is whoever takes the child into their home, and that person must be over the age of 18, fills out the caregiver's authorization affidavit, which is available online. There's multiple versions of it. Caregiver's authorization affidavit, it's called. That allows them to have a level of control over the school and anything medical related at school only. If it's a relative that takes the child in, with the caregiver's authorization affidavit, it heightens the level of control. It gives them power over outside of school medical and dental decisions as well. Okay, so, and once again, if that child stops living with that person, that document is null and void. They have to live with that person. And they fill out one document for each minor child, one affidavit per child. Interesting, times we're in. We had never heard of these things before. These are pretty recent things for all of us to be dealing with and hearing about. Guardianship, not as much. It's been around for a very, very long time. But this caregiver's authorization, etc., these are all emergency things that were created recently. There are wonderful websites out there full of information about these, very easy to understand information. And I welcome you to go look at them. A lot of these nonprofits cover it. A lot of government agencies have these as well. These are California specific. It's not for outside of California. And another thing to clarify, there are power of attorneys that we all know about. Those do not transfer parental rights or do not give any kind of guardianship rights to a parent. Powers of attorney are for financial transactions. So just kind of stepping away from the parental rights and going into, let's say the child is there and we want to provide some money for the child. You have your ability to transact with your telephone, obviously, Zelle, whatever, but at the same time, what if you own a house or a business or something that, that needs the input or control of a third party, a friend, an agent, somebody you trust? So preparing a power of attorney for those financial things is a great idea, but what if you don't have one? Well, the great thing is a power of attorney can be signed remotely, meaning outside of where you are, so long as that document is executed properly and it's notarized. Let's say they deport you and you're now in a foreign country. You can have a power of attorney prepared here in the United States, sent to you, and you can go have that notarized in the country where you are. Typically, a consulate or an embassy of the United States will have a U.S. notary there. Also, you can have a power of attorney prepared there, translated and brought here. But these are other issues that are beyond the scope of what I wanted to talk about, but there are other things that mesh in with this related to the financial aspect. That's pretty much what I wanted to talk about with this regard.
So your strong recommendation is, especially for those families that either are undocumented or going through their documentation formalization process, get into it, start planning right now so you're not unpleasantly
Right.
surprised.
It's an unpleasant conversation, but it needs to be had. Not unpleasant, it's just, preparing for the worst, basically. And having talked about it is much better than not. And it's something that's very important. It's a very heavy topic, and it's very important that it happens sooner than later.
Let's go follow-up question.
Sure.
The GC 211 form, does that form need to be filed in court, or is that just something you fill out?
That's a part of the guardianship petition. That's in addition to that. That's a good question.
Luiza, you wanted to get into a few
Like scenarios. Examples.
Scenarios.
Sometimes it's easier to explain what I'm referencing this way. Okay, so scenario 1, an ICE agent arrives unannounced at a food processing facility requesting access to employee break room, right? The employer responds, receptionist calmly asks agents to wait and contact designated HR or legal person. HR requested documentation. There is no judicial warrant provided, right? So therefore, access to non-public area is denied because there's no documentation. The lesson learned from this example is that you have to train your staff to delay and escalate ICE interactions. Verify all ICE documentation. If there's no warrant, there's no access. Document all events and communicate. Next one, ICE delivers an administrative subpoena requesting I-9 forms and related documentation for audit. The employer responses, the office administrator immediately notifies company counsel, only I-9 records were prepared and redacted for submission. This is why it helps to do this in advance, right? Employees affected were notified within the required 72 hours. Lessons learned, do not produce records beyond the subpoena scope. Notify affected employees as required under state law. and respond within 3-day time frame carefully and with documentation. So whatever you do provide, you have to have a copy of what you did provide and when you provided to make sure it shows compliance. Scenario, ICE agent arrives with an administrative warrant for a specific employee suspected of immigration violation. Employer's response is the receptionist contacts HR. HR requests to review the documentation, which is the warrant in this case. Legal counsel confirms it is not a judicial warrant and advises not to produce the employee. The employee is not brought to ICE and is not informed unless ICE has the proper documentation. Again, this is very important to understand the distinction between a judicial warrant versus an administrative warrant, because the two have very different consequences. Sorry, did you raise your hand or was that my...
I have a lot of questions. I can't contain myself.
Oh. And of course I can't see, so I have to be closer. Yeah, why don't we just open up for questions?
Please.
Wait.
Hold on.
He had multiple, he had both hands on.
So, from a business perspective, when you're advising as a business owner, your employees what to do when an ICE raid is in process, how much of it is practicing law? I mean, I really don't know if I feel comfortable giving advice, and some of that advice sometimes gets misunderstood or misconstrued, and now you have a upset employee saying, you told me
To say X, Y, and Z, yeah.
to not produce, not cooperate, or cooperate, or that kind of translates. Is there some safeguard to say, like, this is for educational purposes only and not legal advice? Like
No,
you gave
well,
us,
sure, as a business owner, unless you're a lawyer, you're not really giving legal advice, right? You're just saying, you talk to your lawyer, let's say I'm your attorney, you call and I say, okay, say X, Y, and Z, prepare cards what your employees should say, and you provide it to your employees. It's training. You're not giving them legal advice, you're educating them of their rights, because ultimately, this is an audit of them, right? They're asking for their personal information. So you're protecting your employees of what their rights, and you're protecting yourself, because if you reveal too much, now you're in a potential liability for revealing their medical, their personnel records. So it's a careful line. So being prepared in a sense that you tell your employees, hey, these are your rights, this is the script, if ICE comes, this is what you say. Remember, it's about consent. If you don't give consent, right, if you don't voluntarily give information to ICE, unless they have a specific judicial warrant, you don't have to talk to them. So that's your right. It's just like your Fifth Amendment right not to self-incriminate. So it's essentially, that's what it's about, educating and informing your employees and having protocols. I can't emphasize that enough. You need to talk to your employees about this now, not when it happens. Because when it happens, they're all gonna fall apart because people panic, right? So it's like workplace violence prevention plan. You gotta train your employees so if violence occurs, they're prepared, not that they're experiencing it for the first time.
So it would be like, look, my attorney said, this is what we should do.
You can't say that. Yeah, now I'm on the hook and that's fine because I know what I'm saying.
So both of you gave so much food for thought, I really have to say, and I have a million questions. I want to try to put it in the context of what a lot of us have said and heard, and you know, there's a lot of stuff going around on the internet, on television. So, for you, Luiza, if I may ask this, this public-private space, we've seen the car washes, we've seen the auto body shops, we've seen, you know, the cook in the kitchen. But are those private? I mean, how do you put that into context? Is where the cars are being dried, is that a public space? What is a private space in a car wash? Is it where the owner is there? What's a private space at the auto body shop with that little office where the owner is there, you know, smoking his cigarettes and you know, you drinking Armenian coffee? I don't know what the private space is over there. And then just a couple more follow-up questions on that. All the things that we see, what is your experience? Are you telling us, are you telling us, do they have some type of warrant? Is there an administrative or a judicial warrant already there, but it's being sort of like this, sort of, it's now fantastic. You have these big guys in ICE, and they're coming with their pickup trucks. What, are they not telling the other part of the story in that video reel that they did have a warrant? And then finally on that part, does the employer have liability from, not regulatory liability, but from the guy who's been taken in for violating his rights, like allowing access to a private space? And can that employer be sued by me, and I'm undocumented, and can I sue you because you shouldn't allow that guy to come and take me away? And then real quick, Frashito, if you can hold that, those forms, is it way too late if you do those forms after you've been taken? It sounds like it's too late because those forms have to be done ahead of time. And hold on. And then, as we know, immigrant cultures, especially the Armenian culture, we don't want to do forms. We don't want to send anything into the government. We don't know what's going to happen because of that. So I would think that there's a big disincentive by our Armenian traditional culture to put anything like that into the government files.
Right. One form, let me go fast,
Yeah,
because mine's
yours
fast.
was one, mine was 3 parts, so go.
The caregiver's authorization affidavit is filled out by the caregiver, not by the parent who's deported.
Okay, so you could do that.
So it's the caregiver who has the child in their home. That's very important to clarification. The other one, the guardianship nomination form,
Right.
that's, you nominate, you say, I elect this person to be a guardian in case I'm taken, and in case there's a guardianship petition filed, then I would like this person to be appointed before my immediate family members, for example, for whatever reason.
Okay.
Good questions.
Can the caregiver form be dangerous though? Let's just say you've got, her parents and my parents, and I don't like her parents, and vice versa, and whoever gets there first, because I've got the children, we're claiming them.
Whoever has the child in their home. If
Remember,
the
you
child's
waive it if
16,
they're not
if the
there.
child's 16, they're gonna punch their way out of the house. But if the child's 4 years old, they're not gonna really have a choice. So in this emergency situation, that's basically what happens. And then guess what? If there is such a thing, one or the other will go to court and present a guardianship petition and say why that person is better than the other person. And everything has to be done for the best interest of the children. That's really what the courts look at. Great questions.
Thank you.
Okay. My memory better be good. Okay, part 1, private versus public space. It is very tricky with certain industries like car washes. We actually have car washes as clients. We have clients in very tricky situations. We have mobile drivers. We're like, how do you make that private? If it's possible, I think sometimes in certain areas, like even with car wash, if you could put certain areas like a curtain that says private, even if it's not an official door, to have a line of separation. But if you're outside and you're drying your cars, that's really hard to do. I'm not gonna lie, that's very tricky. I think car washes are very easy targets for that reason, because there are certain things that they can do that's indoors that you can separate, say that's private. But if they're coming out and drying it out in the open, that's very tough to do. So that's
How
part
about the
1.
premise? Do most ICE raids, are they premised on some type of warrant? Would you say that
Yes.
virtually all or 100% of these raids have a foundation of some type of warrant?
No, 100%. First of all, I don't know 100% of the warrants, but I can tell you personally, because we've had these happen to our clients. They have 0 warrants. They don't have a notice of inspection. They just show up, or they wait right outside the parking area where people are coming, and they start talking to people. And employees, seeing the badge, again, they just volunteer information, right? Hey, where's your coworker? Do you know where he lives? And so this is why training your employees, knowing what to say, and most importantly, again, with criminal defense is the same thing, which is what not to say, right? Keeping it zip is really important. But if your employees don't know, they get intimidated if they speak the truth.
Is there criminal liability on the individual? There was that one that we saw on the news where the gardener ran into the medical care facility, and the woman that worked there was trying to harbor him. Could she be facing criminal liability for, I don't know what the word is, but in hindering the you know, investigation on the part of law enforcement officers.
See, now you're asking me a criminal question, so I'm gonna look right at my husband and I'm gonna ask him to answer that question.
He's looking at
Aiding
the
and
sky.
abetting and obstruction of justice, those are the two charges that we found Craig to be arrested for. Aiding and abetting and obstruction of justice.
Right, so now you've got an employee who's received all the proper, training, and this person saying, what, you know, I'm not gonna give you this information. And,
Okay.
and now that employee is potentially obstructing justice.
Well, if the employer is not telling the employee, hey, run away from ICE agents, right? The employer is saying you need to stay calm, right? Stay collected, don't say anything, and if there is a warrant for your arrest, then the employer will look at the arrest, and if it's the warrant, if it's proper, and if they're not sure, they can call their lawyer and says, okay, whatever the employee does, ultimately, if the employee tries to run away or tries to obstruct or to do anything, that ultimately is on the employee, not on the employer. Unless the employer is saying, go run, right, then you are taking ownership of that, so.
Do you think the employers have some responsibility that if one of their employees, whose documents they should have looked at, nevertheless get taken, do you think there's an obligation on the part of an employer to pay for that employee's defense in ICE?
I don't think legally
if
they're
not
obligated, but
legally,
they
and
do
if not, why not?
oftentimes they do actually. We have various clients who are amazing employers, and that's what they do. They pay, in fact, they call us for referrals for immigration attorneys because they're the ones paying the bill. And some industries, they have more undocumented workers than others, and so they end up, you know, paying for a lot of attorney's fees. But legally speaking, as an employer, you are responsible to hire only documented workers. So yeah, there's liability in that sense, but in a sense of, are you obligated to pay for their defense fees? The answer is not that I'm aware of. I don't think so.
And I want to remind you of the question he asked about
Oh, did I miss?
about the liability,
Part 4?
where the employer's liability, if they were to not train properly, or the employee allows these ICE agents without warrants to come into that private area, and then one of the employees gets taken.
No,
That's a
because,
good
okay, and
question.
because part of it is this, look, as an employee, what is their job? Their job is to do their job, right? They're to come in to do whatever it is, clock in, do their job and leave. So if the employee is not quite following every single thing on the instruction sheet, right? Ultimately, they're probably panicking and they're not prepared. Can the employee be what, for being non-responsive to ICE agents?
I think the
or-
question is this,
Employer.
can my employer waive my right to privacy? I have
No
my
one can waive
own
your right to
independent right to privacy in that private section, behind that curtain that you
Yes.
just talked about in that car wash. And if my employer says, "Harametsek" to the ICE
Oh, right, you're
agent,
saying, does he have any?
can I sue my employer for,
But what are your damages?
well, a lot, I think.
Yeah.
Yeah.
Well, ultimately, there is no specific cause of action, as in like you violate, it would just be violation of your privacy, especially if you reveal documents that identify your, you know, anything that's outside of section 1, right, that's proper. But the question of whether or not an employer can be held liable, I have not heard of that before, so that's something new.
I would think that it would be the employer saying, you have access, I have nothing to hide, come on in. I don't even need to see a warrant.
And if
an
they,
employer can choose
right.
to do that.
and if the employee is undocumented, ultimately, right, the employee is undocumented, so how can the employer be held liable?
I mean, he could be, because, and not to be rude, and wherever the chips fall where they land, it is our responsibility to make sure that we're not hiring people that are not legally able to work in the United States.
Right.
So, let's be honest, if there's an ICE raid and I've got a whole bunch of people that are not legally able to work here in the United States, and they say, welcome, come on in, we're kind of rolling ourselves under the bus and saying, let's get all these people.
Right, well,
You
you
know,
I mean, and that wouldn't happen if we legally hired.
You hire someone who had a student visa they stopped going to school,
I don't
lost
think
their
most
legal
people are
status.
speaking in that context.
But, yes, but I
They
mean,
give
I
a
think
false
in the,
social security number. We've seen that all over the place, and so you, as an employer, there's no way to verify that.
Once again, I don't think
So
most
there are a
people-
lot
I don't
of,
think it's in that context. In the context you guys are speaking of,
Which
it is unfortunate.
Yeah.
There's a lot of
Yeah.
students, people that their EADs expire or they're still in the renewal process. That's a different story. But I'm just
Which
saying-
context are you talking about
When the
specifically?
employer is thinking it's
Hold on.
beneficial
Yeah,
to
yeah.
hire undocumented.
That's
Oh, okay,
that's a
fine.
violation
Because you pay
of
less.
Yeah, in that context,
That's-
that's, thanks very much.
Thank you for clarifying. Yeah,
That's a violation of federal law, and the first offense can be as high as $10,000 fine.
And at that point, the employer should be held liable because, they're,
Right.
yeah.
With the caveat, and I will say what Gerard said, which is, at the end of the day, if the employer did not know, and the employee provided a false social security number, and I promise you, I do class action cases and we go through hundreds of employees' records, there are always social security numbers that don't match names. So it happens, but oftentimes employers don't know, right? If you have 400 employees, it's hard to verify. Although nowadays, they're doing a lot of e-verify, so employers are getting more and more sophisticated to verify the information because especially of what's happening right now with ICE.
Okay, I got a couple of announcements, so the time flew really fast. I'm not adjourning or anything. We can sit around and take more questions if needed, but here's the thing. Armenian Bar Association, we do free clinics. This Saturday, we have an expungement clinic, so if anybody can benefit from having some prior unpleasant history expunged, hit us up. We can help you with that. The phone number for Armenian Bar Association for this is 818-660-6898. 818-660-6898. Email is probono@armenianbar.org. probono@armenianbar.org. We have a bunch of flyers outside, so help yourselves. Attorneys can get an hour of CLE from this program. And we also help public that cannot afford paid legal services in bankruptcy questions, criminal law, estate planning, expungements, family law, immigration, landlord tenant, personal injury, social security, disability, general practice type areas
it's on Saturdays,
on Saturdays.
10 to 2.
And it's by appointment only, no walk-ins, correct?
They can walk in.
They can walk in?
It's at the Glendale Adult Recreation Center.
Glendale Adult Recreational Center. Okay, 201 East Colorado Street, Glendale, 91205. And for those who want to get the CLE, there is the form that we ask you to fill out and put your name on the list. That's that. I have some phone numbers and names to share with people that may benefit from these types of situations. First one is Immigrant Defenders Law Center that provides free legal services through universal representation model throughout Southern California. Rapid Response Hotline is 213-833-8283. Legal Aid Foundation of Los Angeles, again, provides similar services. Number is 800-399-4529. California for Humane Immigrant Rights. Rapid Response Hotline is 888-624-4752. Public Counsel, and I have a whole bunch of other names. So this is available through Armenian Bar. If anybody wants to get the full, complete list of this, you're welcome to contact us. And my recommendation is share with your neighbors and those that may benefit from it, and they should keep these numbers on their speed dial, basically, if needed. Any questions?
Actually, to follow up on hers, that incident I think happened in San Bernardino County, right, where the guy ran in. Does the employer have liability in a situation where I believe that nurse fought back or tried to hold him back if she got injured or someone else got harmed because of her actions in the workplace? Does the employer now hold liability because of her actions?
It would be premises liability because that person is not the employer's employee. That would be a premises liability, not an employment law issue. It would be an employment law issue when an employee acts in a certain way.
That's what I'm talking about, the employee. I'm not talking about the guy that ran in. I'm talking about the employee that tried to help, I think with, what's the word, like stopping the
The
arrest?
gardener
The
for
standard,
the location ran into the facility, and one of the employees, who was a nurse, tried to prevent the ICE agents from arresting the gardener. So she
Oh.
put herself in the middle of the situation and was trying to fight off the ICE agents.
Yeah, no, that's not an employer issue. That's not, it's not on the employer when the employee acts basically in violation of the law.
But what if their actions also harmed another employee at that point? Like it's a chain reaction. And I know they're
If the
hypothetical.
employees harm, any employee that's harmed at the job site, that would be a workers' compensation claim. Regardless of who was the cause of it, which is a different animal of its own. It's called
Well,
workers' comp appeals.
They're gonna look at it whether that activity was within the scope of their employment or not. If they did something outside of their scope, or which seems to be outside of their scope to harbor a fugitive, right?
Yeah.
So, yeah, interesting, a lot of interesting topics here. Yeah,
All
of
right,
course,
well,
thank you for the
thank you,
questions.
Gerard, thank you, Luiza, thank you, Mr. Thank you, Lucy, thanks, Armenian Bar.
Yeah.